cover over the year. We're starting with contracts, next contract admin, variations and EOTs and delays, a deep dive into those, a look at design responsibility, and then latent conditions, progress claims, which are important these days, defects and quality insurance, that is, making sure that your risks are covered, and finally, dispute resolution. Now, of course, all of these topics interact with other topics. And so in some of the discussions we'll have today, we will deal with matters in other topics, and we'll review them when we come to them in turn. Please feel free to ask questions during the running of the seminar, and otherwise I think it's probably best to remain on silent, but if you open your mics, you should be able to be heard by us all, and the discussion will benefit all of us. So if we go to the first slide, we've got to have a bit of an idea of what contracts are doing and where we want to sit in the contract sort of spectrum. And that is what I'm suggesting is they should be fair, but they should be firm contracts. That is, when you're drawing them, you need to know what are the limits of the responsibilities of the other contracting party, and what are your responsibilities in making sure that you do your part of the contract. This is founded on a belief that it's a rare occasion and not too glamorous occasion where you get something for nothing. Basically, you expect to pay a fair price for fair work, and you expect there to be a relationship throughout that contract that ensures that everybody from that contract gets a fair reward for the contribution he makes. The contracts also distribute risks via contractual provisions, and in some instances that's very efficient and fair. On some other aspects, it's not. For instance, it's appropriate to say that a tradesman must deliver properly performed work, that he can't be shoddying his work or be careless on it. On the other hand, there's a trend in contracts these days to introduce onerous indemnities, which try to transfer risks simply because one's in a position to enforce them on the other party. Inevitably, in my view, that's inefficient, and it means that there's awkwardness in how parties relate together and how they react to those unfair risks. Contracts also provide a competitive market in the short and long term, because they allow people to quote for work, and those quotes can be compared with other quotations to produce a proper result. And it promotes better managed projects. If you have a wide number of people and no definition, no specification of what's got to be produced, then you'll find that it's not well managed. Again, in construction and construction contracts are a contact sport. You can be hurt by them, and it's not a social club. It doesn't usually run on a social club aspect. So it's against that background that we need to look at the contracts that are going to protect us and also going to fairly reward the other party. So if we go down again, the next slide, you've got to look at the aspects of a contract. Firstly, there is the technical side of it. That is, that if you've got a project, you need to have technically competent people inputting into the management and the contracting of that. Again, you have to have some sensible idea of the financial. For instance, a client of mine put in a bid for a project, but he didn't add it up properly and he didn't allow for a whole slab of work, but he put in for a lump sum contract. The other side then insisted that, well, he should perform the contract even at a financially disastrous rate. The situation was eventually, by negotiation, he carried out some of the work, but was able to avoid the loss that would have come from performing it all. So it's important to make sure that when you enter contracts, you've got the financial straight. And the contracts and the terms of them are essential to success. And again, we've got to plan, we've got to implement, and we've got to monitor. It's important that there is a philosophy of planning for contracts and contracting projects, then implementing, and then monitoring that and leading to better improvement over a period. The next slide is you've got to be a little bit careful these days about your social contract initiatives. Society generally expects people to provide, for instance, a very safe place of work, and you quickly attract criticism if you don't do so and you don't demonstrate that you've done so. And again, in terms of employing people, there's a great sensitivity to people underpaying employees. So you've got to be careful when you're doing contracts that you don't contravene what would pass or not pass the pub test of being reasonable and sensible. If we go on, you'll see an example of that situation where fracking, the extraction of gas through injection of fluids into the ground, was not properly debated, discussed, or consulted with the community in respect of, and that led to a situation where it was eventually banned. So one's concerned to ensure that when you're contracting, you're demonstrating a sensitivity to community expectations and producing in accordance with that. So if we go down a couple of slides, Jonah, to go to. One of the importance about construction contracts is the role of the superintendent. There has been a long history of having a third party involved in the administration of contracts. And up until, say, the 70s and the 80s, that worked very well. Superintendents were impartial. They were usually a consultant employed by the principal, but they usually decided matters of variations, extensions of time, and defect rectification on a reasonably competent and impartial way. The employer was always responsible for the superintendent, and therefore if the superintendent made a bad mistake, you could take him to arbitration and have a claim in respect of it. These days, however, the role of the superintendent is changing. Principals are adopting less generous provisions to a superintendent, and they're providing that he's an agent, he's not a certifier. That is, they're providing that he is doing what he's told, not doing what he thinks is right. And there's an important distinction. And that's made a lot of contracts more hard-edged on the contractor than previously. Previously, the obligation on a superintendent was timeliness, being fair and reasonable in his assessments. And that's still to be found in the AS 2124 family of contracts, where that is expressly provided to be what the superintendent will bring to the contract. But increasingly, that's being written out in more modern contracts where principals are wanting a hard-edged role for the superintendent. We go to the next slide. Now, there's an important case of Balmain Peninsula and Abbey Group where the role of the superintendent was taken to court. And the contractor said there, the superintendent had an opportunity to grant an extension of time. And given that he had an even-handed responsibility to both parties, and he knew that there was a proper basis for an extension of time, he should have granted that extension of time, notwithstanding the contractor had not applied for it within the time period specified under the contract. The courts agreed with the contract on that occasion and said, well, the superintendent did have the opportunity to provide it and he should have provided it. Increasingly, though, the issue became one where, by virtue of the conditions of contract, the opportunity for the superintendent to be even-handed has been written out. So it's an important aspect and important measure of the contract, first off, that you look at the superintendent clause and to see what role the superintendent is playing. Is he an impartial certifier, bit of an umpire, or is he really just doing what the principal tells him? If we go to the next slide, what one should do before a contract's signed is to identify the risks in the contract. So one should list the risk that one will have. If one signs a contract to excavate a deep excavation in a city, for a city building, one needs to know, well, hang on, there's a problem of rock, it might be too hard to dig. There's a problem of instability of the walls, they might seek to fall in. And there's the concern over neighbours and the impact it will be on neighbours if there's any settlement of the surrounding sites. So one should, before one starts off, list the risks, rank them as high, medium or low. Is it likely that there will be some hard rock? Is it likely that there will get some dilapidation on adjoining sites? And then estimate the costs of those occurring. So one has a bit of a perspective on where it is that this contract is taking it, what sort of risks are going to be incurred. And then you've got to monitor the risk, because there's no point putting your head in the sand and saying, well, hard rock will be difficult, if one doesn't then check in every Friday with the person excavating the rock to see whether it's hard or soft. And it's important to plan a response. If it is hard rock, what are you going to do about it? There's a limit to what can be done if you've got a machine on site and the rock goes hard. However, it may be possible to get a bigger machine in at some time, or to undertake exploratory drilling ahead of the excavation so that one knows what one's encountering. So it's important to look at the risks that are on the project and the risks that the contract can make adjustment for. And the other aspect is you've got to look at compliance with the contract. There's a risk if your administration gets messed up, you can often be left holding a substantial portfolio of disadvantages if you haven't been timely in your administration. So if you go to the next slide, I want to look at a very important aspect in most construction contracts is variations. And one needs to look at it upfront and to see what is the likelihood of variations. Now, on the normal circumstances, you say, well, we can't judge it because the superintendent will make those when and if it suits him. But it's often important to review the status of the design, to see how detailed it's been done, and to see whether or not it integrates properly. A well-prepared design might have a lot less variations than something that's been thrown together in a hurry to get the building started. The other aspect is variations are almost inevitable. That is, it's a rare construction contract that gets to a finish line without having looked at variations. And it's worthwhile looking at some of the contract clauses, and we've picked AS 4300 as to a general approach to variations, and also, therefore, an approach to what you've got to provide for in terms of protecting yourself in respect to variations. One can expect, of course, that variations will cost more than tendered work. The reason for that is tendered work is pre-programmed work. It's work that's been carefully reviewed, carefully discussed, and carefully priced. And it's obviously been able to be subcontracted with certainty because the circumstance is that the subcontractor has a definite scope of work on which to price. With variations, the opposite sometimes is true, in the sense that the variation is often unplanned. has to be done urgently because other work is going to follow it and needs to be kept on schedule. And the detail of the variation is often pretty rudimentary. That is, you might get an instruction to move a window a metre to the south. It won't come, perhaps, in a lot of contracts, it won't come with a detailed specification about flashing and everything else. You'll be expected to make it happen, but it won't come very well specified. So the situation is it's important in construction contracts to understand the broad ambit of variations. The question, of course, is that if you have a contract which didn't have a power for the superintendent or the principal to vary the works, then you wouldn't be able to vary it. Then you'd be in a situation where you'd either have to forget changes to the contract or else negotiate with the contractor as to that. Because the contractor is on site and doing a wide range of work and needs to control the site, it may be that that negotiation will end up with a much higher price than if it was already agreed in the contract. So 40.1 says that the superintendent may direct the contractor to increase, decrease, or omit any part of the work, change the character or quality, change the level lines, etc. If we go to the next slide, the superintendent can also ask the contractor to price a proposed variation. That is, he wants to shift windows, but he's a bit concerned about the cost, so he proposes a variation and the circumstances that he gets from the contractor a proposal of price and time. And the next slide, if you can. So then you'll get variations for the convenience of the contractor. The contractor might say, well, it's more convenient for me to put a steel beam in than a concrete beam. And the circumstance, if that's the case, then he can apply to the superintendent, who again will work through and see if that's an acceptable adjustment to the scope of works and adjustment to the price that comes with it. So if we go on further, the provision of valuation of variations is always a challenging matter in construction contracts, and it always gives rise to the potential for a dispute between the principal and the contractor. The situation in this clause 40 tries to provide for some adjustments if the variation involves not only perhaps a saving in cost for the principal. He might say, well, I don't need that front fence, but it seemed there's an undercurrent that perhaps it's unfair to the contractor to ask him to have tendered on a job that will last for 9 months and has everybody in his staff and his equipment allocated for 9 months. And then if the work is reduced, perhaps a contribution to his overhead and profit might be sensible in all the circumstances. So, and if we go to the next slide, we've had a look then at variations. Variations are important and they must be looked at carefully. Additionally, the valuation of variations is very important, and it often is vital that you include pricing schedules in your contract, which say that if you order 3 more cubic metres of concrete to be laid, that certain amount of price will be adjusted. And it's important that those rates are sufficient to do the work and obviously not excessive. It's important to understand that there may be differing levels of profit for a contractor depending on the amount of work he gets at that rate. So say, for instance, there's a price that removing water from the excavation will be priced at so much 1,000 litres. Now, if he only withdraws 1,000 litres, you might have had to set up the pumps, set up the pipes, do all the work and only get 1,000 litres and a small amount of contribution. Whereas if he set up the pipes and pumps and could drag out 50,000 litres, he might make a lot more profit. That is, that the costs of setup and mobbing and demobbing are such that they'll affect the price he gets even with a constant amount. So if you're concerned about that, you can see a risk, it might be appropriate to say, if there's less than 10,000 litres, then it'll be a certain amount. And if it's more than 10 to 50, it'll be a certain amount. And over 50, it'll be something perhaps less. So that's variations. It's fairly basic, but you've got to follow it through carefully. The other aspect is that it's important for a contractor not to exaggerate a variation, and important for a principal that he pays fairly variation. There are often disputes over variations that can go on if either of the party adopts an unreasonable attitude. But variations are a constant in contracts. You should be careful to read the variations clause, and you should be careful to make sure that you've notified your claims within the time that the contract provides. We then come to time is money, which is an area that gives rise to extensive disputes and uncertainty in contracts, which is inefficient and doesn't really assist anyone. So before the contract's signed, develop a contract and a target program. The situation in a contract program is what you have to do, but it may be more sensible and may be useful to have a target program. That is, you're going to try and finish a month early, even though you don't have to. And this gives you a better assessment on whether or not you'll reach practical completion at the right time than the contract program, which can often be in a state of flux depending on the interpretations and the assessments of the superintendent. The other aspect is you've got to keep on top of the program. That is, you've got to identify delays every Friday. You've got to do it on at least a weekly basis. And you've got to claim delays every Monday as quick as you can, because unless you do that, there's no notice to the other side, but also it's very likely that the time bars that are incorporated in the contract will disqualify your delays complying if you don't notify it promptly. The other aspect that a lot of contractors miss, but is usually included in any delay clause, is the need to provide a new program with each claim delay. So if a contractor claims that he's been delayed for a month, then he's under an obligation usually to provide a program that shows that he can recover some of that time and that he has taken steps to avoid any further delay. That means you've got to reprogram. It's important from a contractor's point of view to make sure he retains on top of that job and he has reprogrammed it successfully throughout the process. That if he's had 20 extension of time claims, he's put in 20 adjusted contracts. You've also got to estimate your delay costs. If the delay costs are going to be practically nothing, then it goes without saying it doesn't raise a big problem. But often contractors don't estimate delay costs, and then after 2 months or 3 months of delay, they then realise that it's having a massive impact. It's better to be early and, if necessary, wrong, rather than to be late and even if right. The idea of giving early notice, working out what you think is the potential impact, and then following it up with the notice to the other side is essential. You ought, in that extension of time claim, list the steps you've taken to reduce the delay. It's inevitably a condition under the construction contract, and if you list those steps, it's obviously easier to prove them and establish them and to get credit for them if one later requires an adjustment in time or money. And you've got to comply with the contract. Talk about time bars later, but the situation is compliance with the contract is good housekeeping, but it's essential. So if we go to the next slide, you've got to be careful to identify the causes. And the cause of a delay, if it's on the contractor's side, say his equipment breaks down or his blokes don't turn up after the Christmas party or something, or somehow they make a mistake, then that's pretty okay, and usually you don't get extensions for it. But there's a lot of neutral clauses, that is, clauses that are not the fault of the contractor or the principal. So the issue is you've got to watch those as to who they're allocated to. I was speaking at a seminar recently, and there was a state manager of a major contract there, and he identified that it was a very substantial risk, that of weather obviously wasn't controlled by either party, but it had a massive impact. So you might have 3-4 weeks of wet weather that prevented much work being done, and the contractor had to bear all these overheads during that period, and also had to bear the wages and other costs that were associated with it. So, and couldn't, in the next job, he wouldn't even be able to learn from that experience and do a better estimate of the weather because it was fundamentally random. So it's important that you identify these neutral causes and say, well, whose risks are they at? So if we go to the next slide, time extensions. You've got to make sure that your contract details the permissible causes. That is, for what do you get an extension of time? And often contracts are quite limited in the causes that will entitle the contractor to extension of time, and not in the view of many, is that efficient, because the situation is it means that the contractor is under unfair pressure to get the job done despite what delays he has, and that causes knock-on effects of misestimating various aspects and trying to rush through jobs in a quick time. You've got to look at your contract and determine what the cost or impacts are, because oftentimes contracts say, well, you won't get much for the delay costs. You've got to look at that as a sensible risk and make sure that you've got provision for it in the pricing adjustments you've made. So one aspect is, of course, that if you have, for instance, weather, and one contractor thinks it's going to be very wet weather, so he puts 10% on top of his bid, but another contractor who doesn't think it'll rain, doesn't think there'll be a weather problem, put 1% on his bid. If you don't show some sort of recognition of how much everyone is adjusted for, you're often, from a principal's point of view, looking at apples and oranges when you're judging tenders. So in terms of the best sort of approach to it, it would be better to say, please allow for 20 days of weather extensions, after which there'll be an extension of time. It's not traditional to give cost during weather, but at least the extension of time after a certain provision should be available, in which case then the contractors tender on a common basis. And the situation is that if there is a fair allocation of the costs of extensions of time between principal and contractor, it's often they're both incentivised to make the project run carefully. If the principal bears none of the risk, then the contractor has to wear it, but eventually then he looks for claims that he can pursue on other levels, as well as the time extensions, in order to claw back some of the loss that he's suffered as a result. So if we go to the next slide. And the next, I think. So variations in EOTs are often intermingled. Sometimes the variation doesn't cause any extension of time. If, for instance, you're told in good time that the main door should be painted white instead of blue, presumably if you haven't yet ordered the paint, it's pretty simple, and the variation, the blue might be more expensive, but there should be a simple adjustment. But often variations have complicated interactions with delay, because if you're asking for a variation, for instance, what sort of plumbing work done and varied, it might only be adding a small amount to the plumbing work, a couple of days extra work. But if that contractor has already committed himself to other work and therefore can't schedule that 10% of work into a program, if he has to say, well, look, I can't do it for 4 weeks, then the circumstances of variation, ET and EOT are very much intermingled, and you've got to be careful to do it. Additionally, one should, as a matter of analysis, say, well, on what basis I'm awarding a variation? You could say, well, I'm ordering a variation and you should be able to fit it in with your existing work and it won't cost you any extension of time or any real cost. Or it could be a situation where you're ordering a variation on the basis that there'll be new resources dedicated to the project that'll carry out the variation without any need for an extension of time. And sometimes it's a bit obscure and left to judgment as to whether the variation involves an extension of time. So it's important when you're ordering variations, it's important when you're claiming variations to make sure that you've looked at the delay impact and the extension that's required. So that's there. If you go to the next slide. This is a interesting concept, usually applying to complex projects. But the issue is that if the contractor can finish early, so the project program is 12 months and the contractor is pretty confident can finish it in 10 months, then there's 2 months float, there's 2 months gap. And the question is, well, who gets the benefit of that? That is the contractor getting the benefit so he can manage his resources so that he can creep out from 10 months to 12 months? Or is it not? Is it a situation where the principal is requiring that float and expects the contractor to finish promptly on 10 months, not 12? Often there's a concern and a dispute between the parties as to what sort of leeway owning the float gives either the contractor or the principal the opportunity of flexibility in their programming requirements. So if we go down another slide. One aspect is the situation is sometimes the programs are very, very complex, and one wonders whether or not we're using a program to identify a work schedule in detail enough for a contractor to program his resources, but that for a contract situation, you need something that is a little bit more general and a little bit less specific. So you've got to be careful that your programs are too complex and therefore they can't be made to work. One wonders whether or not one has to specify all the projects to the hour, or does one specify it to the week or the day or the month? So do you have a simple bar chart that says we'll excavate for 6 weeks, we'll then put in the foundations for another 6 weeks, and after that we'll build the building, rather than carefully monitoring and prescribing when and where each particular excavator is on time? So look at that aspect, because time is very important, and time often develops significant sort of disputes between the principal and the contractor. So if you go another slide, defects. So in the run-of-the-mill construction contracts, defects are a bane of someone's life. And if there are lots of defects, the project is under stress, and it often comes out with a result that's a success to no one. So the issue is here, you should develop some clear approach to defects as you look at a contract. So the situation is that defects should be avoided almost at all costs. It is a situation that if you get somebody who does quality work and doesn't have defects, he's much more valuable than somebody who's inexperienced, out of his depth, and is causing problems. The other aspect, you've got to realise these days that there's often a layer of clients and stakeholders involved in the project. So there'll be a financier, there might be a subordinate financier, there'll be an investor of some sort, there'll be an owner of some sort, there'll be a contractor, and there'll be subcontractors. Now, if it gets to be the case that the subcontractor is viewed as having lots of defects, then it'll cause strains on the relationship right up the feeding chain. So it's important for contractors to say, look, we have to avoid the defects. We have to get sign-offs, and we have to control the quality of the work so it comes out in the right way and at the right quality. The scenario is, as well, one should record as a contractor the method of work and the final result, and time and locate the photos. The issue, say, for instance, if you're a subcontractor who's required to waterproof 20 bathrooms in a high rise, the situation is that each bathroom should be carefully checked, photographs taken of the method of work that was implemented, and the quality of that work. And these days, there's very little in terms of excuse for not recording the exact work done on each item of work. The example is obvious that if you send a parcel to the Prime Minister in England, that parcel will go through DHL and be measured and accounted for at every step along the way. And it will probably only cost you $100. Yet, the waterproofing result in high-rise developments often is not recorded at all, and there's no one's got a clear record of what's been done and how it's been done. So it's an aspect which is becoming clearer and clearer, and unless the contractor carries out that process, usually for next to nothing in terms of cost, then it creates an enormous problem later on. There are difficulties with, and using the high-rise, multi-dwelling construction is often the source of very difficult and expensive disputes in construction contracts. So it's important to watch defects and the quality there. It's also important to obtain sign-offs, to have hold points that are cleared officially with a sign-off, so that somebody has actually checked it and said, yes, that's okay. Otherwise, one's got a lot of work done and no one has really inspected the work on it. The situation often develops between contractors and principals as to what do you do when the principal claims an enormous amount of defects and the contractor says they're not defects, they're all right, they're within tolerance. The concern from the contractor's point of view is that he should carry out those defects, fix the defects, and if he thinks they're beyond the pale, that is, they're unreasonable, then he should claim a variation for that work. That way, you end up with a limited dispute at the end as to the 20% of variations that were unreasonable. You don't have a dispute where the principal contracts with another contractor to carry out the defects. That other contractor, sensibly, to preserve his own position, spends twice or three times the amount on fixing the defects. And then there's a real dispute developing between principal and the original contractor. The other aspect about instructions as to how you carry out work and how what is acceptable and what's not is to make sure that you've got all your instructions recorded in writing. So there's no backsliding later on when people say we didn't agree with this, we didn't have that. And again, if you've got a defect that's been identified, and if you say in order that that defect is remedied, you've got somebody coming on to inspect it, have a sign off of the rectification. Otherwise, the cost of going back to do more of that work will be close to ruinous. And if you go to the next slide, time bars. They are considered a necessary evil in construction contracts. That's saying if you claim a variation, you must claim it within 7 days of being given the instruction. If you don't, you are barred. Now, time bars will work if they're well expressed and cover the particular transaction in question. But the problem is they're ruinous if you're on the wrong side of them, because a contractor might have to carry out a variation that might cost him 100 grand, and because he was, in theory, a week late, in notifying that cost or complying with the contract in some way, he loses that 100 grand. So it's very important to be alert to the time bars that apply. And when one's looking at a contract, one should identify each time bar and make sure that that's clear to any contract administrator in order that they don't mess up. The situation as well is when you're negotiating contracts, you should consider sort of realistic timetables. If 28 days is a much more sensible timetable for most of the problems that one gets into, rather than a situation where there's 5 or 7 days imposed, and it's very hard for people to understand the impact of a variation or a latent condition or a change in direction or change in program within that time. The other aspect is if you make them too short, you can sort of affect the culture of the contract. That is that if you make it so you've got to notify within 3 days, it means that the contractor has to serve notices of claim every 3 days, and it soon becomes an unnecessary burden for the principals and his staff in administering them, and it has a deleterious effect on the contractor because he's got to go around thinking of claims all the time rather than getting on without the job in hand. So if you go to the next, I wanted to look at the avenues one's got to resolve disputes. And it's important when you look at a contract to try and establish whether or not you're going to be able to resolve disputes in a simple and less expensive way, or if you're going to be forced to go to litigation or arbitration. So the situation is that the types of claims that you get under a contract, you have breaches of contract where the principal locks you off-site or the principal issues an unauthorised variation or whatever. And then you have the Trade Practices Act or the consumer legislation these days, which says that if you're misled at the time of putting in your contract, then given certain situations, you can recover claims on that. So say, for instance, a dam builder is building a dam and discovers that there's a whole lot of backfill that's been put there years ago, and he has to dig it out first, and that costs him a couple of $1 million. He will then turn to the principal and say, do you know about that? And if the principal drags out a map or a plan from years ago that showed it there, then maybe there's a contractor who's got a claim for recompense under the prohibition against misleading contact. The other aspect is there's always an aspect of frustration if some aspects of the situation change and the contract can't be performed in the way that it was originally intended, then it may well be a situation where the contractor can seek to have an adjustment under the provisions that relate to frustration. So you've then got to look at what ways you can resolve things. You can resolve things by negotiation. It's the basic and first stop. And to the extent that you can, it's well worth trying to. By negotiation, you can settle a $100,000 problem in an hour. If you take that same problem to court, you'll probably spend 12 months and multiple hours in trying to define exactly the dispute and define the various aspect that evidence is in to prove every aspect of it, and it's inefficient. The other aspect is that mediation is a very favourite topic in Australian construction. That is, you arrange mediation, which is the meeting of everybody with a mediator or a person that sits in the middle and tries to help people come to a settlement. Now, mediation has a disadvantage that it doesn't necessarily reach a resolution. If the parties are not wanting to agree and don't come to an agreement, then the situation is that the mediation will fail, and usually the mediation is without prejudice, so everything that's said there is confidential, and the situation is you have to start again in a different process. So mediation offers you the opportunity of settlement, but doesn't provide a certain settlement at the end of it. The alternative is an expert determination. So you can go to an expert to say, we have a problem over the valuation of this variation. We're $100,000 apart on this valuation. And the expert will conduct some inquiries and do some analysis of the situation, and he will come up with a decision. And if he follows the requirements of what he was asked to do and conducts himself in an appropriate way, his decision will usually be 90% so, adopted by a court if anyone wants to debate it. So expert determinations is a good way of resolving disputes if the disputes are simple and straightforward and the expertise of the expert is in the relevant field. It gets more difficult when more complex problems, but experts can resolve a lot of things quickly and easily. And you ought to be careful to suggest that to the other side, to say, well, look, if we can't resolve it, if it's under a couple of grand, under 200 grand, let's just refer it out to an expert and then we can get rid of it. And you're trying to maintain the relationship while getting rid of the disputes. Then you've got arbitration. Arbitration is a more formal process. It differs from court in the sense that you can choose the arbitrator, or he can be nominated by an institution that you've agreed to. And the arbitrator will run it more or less as a litigation event. It's just a little bit quicker normally, and it is a bit more controllable because the arbitrator will make sure that everyone's keeping to the timetable, and that each party has to be looking like they're doing a proper job, because the arbitrator that sees the interlocutory steps also makes the final decision. And if he gets a bad view of the one or other party during that interlocutory and preliminary stage, it's likely that that'll have an effect on the final result. So you've got to be on your toes when you get to arbitration. And then you've got the fallback, which will sort any problem, but sort it expensively and at a high level of information and dispute, so that there's lots of arguments when you go to litigation. And litigation will solve any problem, but it's much more expensive than, say, an expert determination. So it's there as a backstop. It's there as a backstop because the courts have to make sure that, you know, disputes between citizens are resolved and resolved fairly and impartially, and they do a good job of that. But it's quite expensive and quite lengthy. So when you're managing the process, if you stand back from all these types of processes that we can look at and managing that process, one wants to have a view of what one's trying to achieve. If one's just got a punch up with your neighbour and there's no way of agreeing anything and you just got to punch it up, then you're probably going to end up in court. If, on the other hand, you're able to assure the other party that you only want a fair result and that therefore they should sort of accept, you know, an expert being brought in, agreed to by both parties and determining it, that might preserve the relationship, etc. The other aspect is, of course, that the security of payments legislation offers parties, particularly the contractor, the opportunity to pursue a claim and within approximately 2 months have it determined. It's a great benefit if it works well. Unfortunately, it doesn't always work well, in which case it messes up things, but it achieves a good settlement most times, and it's somewhat independent person coming in to determine what he thinks of the dispute between the parties, and it should be pursued. Whenever you've got a claim that isn't accepted, you should try the security of payments, because it will mean that everyone concentrates on the matter, everyone has to put their best case forward, and oftentimes there's the potential for settlement of things that wouldn't otherwise occur. So look at disputes when you look to evaluate contract to make sure that it provides for a sensible way of resolving outcomes. So we go to the next slide. With disputes, here again is selecting a person. You've got to make sure that if you're selecting a neutral, that he is really neutral. So that's an important aspect. It's a bit of an issue with local arbitrations that you might select somebody who's got a range of associations with the other side or some of their advisors. Internationally, arbitration, if you're importing something from China and you want to get some sort of dispute resolution process that's practical and sensible, then the situation is you can select a jointly foreign country resident. So if you're having a dispute with China, you might accept somebody from Singapore, or you might accept someone from France. So somebody who's neutral, won't have associations, can often deliver an invaluable adjudication in international contract. The courts have increased their expedition and their rate of progress in recent times, but still the court procedure is very precise, very detailed and very complex method of resolving things, and a court usually will end up with a more expensive and a longer set of arrangements. So that as a general summary there is the work I wanted to cover today. I'm very happy to take any questions, or you can shoot me a question, or to go to a question by email. And I wanted to ensure that you had a general run through of what are the common issues in a construction contract, so that you feel confident in assessing what combination of obligations and arrangements will be sensible for your project. It makes a big difference, and obviously you don't want the rigmarole that might go with a $10 million contract if it's only 100 grand, or vice versa. But it's important that you go through and carefully assess the contracts that you want to set up because they're important to the success of the program overall. And looking at these various issues, we've got an understanding of some of the risks and rewards and some of the confusions and problems that can develop. And it's important that we have that sort of overview guiding us when we look at contracts to see whether a contract is good, bad, or ugly.